A witness has emerged saying they saw Ronnie Stout pushing a burning car down an embankment, igniting dry grass and brush that is still raging. Innocent, of course, until proven guilty. So is there any defense in this kind of situation? To that end, defense attorney Mark Reichel with me now live. Good morning to you.
Good morning.
So why waste the court's time and taxpayers' money? Somebody says they saw Ronnie Stout push this burning car and then saw the fire start.
Well, we always do when someone's charged. We don't just send people to prison until we have a fair hearing. We use all the evidence in the courtroom, nothing outside of the courtroom, just the things inside of the courtroom. And so here, I think the real focus is going to be whether or not this is what the person intended. He could have been having some type of crazy episode and, talking to the car. We don't know what was going on. And then he throws it down this embankment or whatever. Obviously, when it causes this fire, if that's reckless, you get charged with the crime of reckless arson. Reckless arson can carry a prison sentence up to like 9 years here if they can prove that it was so, non-reasonable what he did, knew this was possibly going to happen, then that's the criminal charge. The other charge would be intentional, that he really wanted this to happen. If he's charged with intentionally causing this fire, his sentence will be much higher. And there are enhancements for how many buildings were damaged and did anyone get injured? Was there great bodily injury? And if death results, a firefighter, an innocent person, you could have a manslaughter charge as well.
Alrighty, Stout is described as seen walking calmly away from this scene when others were in panic mode. So is it harder to defend because witness claims to have not only seen the criminal act, but also what some might say is part of a cover-up in terms of his demeanor?
Yeah, I think they're obviously going to look at his behavior thereafter. But it is, again, speculation. Both sides are going to try to prove. The defense is going to say, well, this is someone who's not really paying attention to what they're doing. They would have ran away and fled and not wanted to be caught. But on the other hand, walking calmly away shows maybe not an awareness of what's going on. The prosecution will say, this is the definition of callousness, folks. This is grossly above what we consider reasonable behavior.
If Stout was your client, what might be your first line of attack to get that witness statement out, if there's any way to do that?
Their witness statement is not going to get out. She doesn't have a video of him doing it. It's just her recollection of things. I think what you're going to really look at is how many times did she hear bad things about this person after what she saw? And in fact, did that go in? And you can't compartmentalize in your mind and put somewhere else bad things about someone. You saw what you thought was a bad thing done. And so as a result, to see how that colored her memory, how that colored her thoughts on what she saw.
Ronnie Stout has a criminal history of lewd acts with a child and robbery causing bodily injury. But right now, as we've been talking about, facing 1 count of arson. You mentioned some of the possible charging enhancements that you might be expecting, the intentional, have you anything else that, a defense attorney would be looking at that might get tacked on to this?
Well, like I said, the big thing you're going to look for is if someone dies as a result, firefighter, innocent person, whatever, dies as a result of this, you could look at a manslaughter charge. That's not unprecedented. That's happened several times in California with wildfires where someone passes away and the charges are up to manslaughter, which can carry just like up to 11 years just for that.
Alrighty, and before we let you go, CAL FIRE reports that more than 100 structures have been destroyed since the park fire started. We're talking commercial and residential. If found guilty, could families who've lost their homes go after Ronnie Stout if he is the person that is held accountable for this civilly?
Absolutely, although I just don't think he's going to have anything, but absolutely they can, and they can possibly go after anybody else for negligence and how they let this happen if that exists.
We haven't heard very much about that car. Don't know specifically just yet, since he hasn't been to court, if that car is his. But if somebody else had a car that perhaps was in disrepair, might have, easily ignited or been ignited on its own, and maybe Mr. Stout was just trying to get away from it or push it somewhere else, could that person who owns the car, if it was in disrepair and started this, also be charged?
Not really, unless it was so likely to catch on fire where they left it, which it doesn't sound like it. It sounds like it was his mother's car. And it sounds like he intentionally set it on fire and then pushed it down the ravine. I think the argument is going to be that he wanted to burn his mom's car, and that's it.
All righty. Well, a lot to sort out here. The very beginning of this case and the very beginning of a long road for the folks who've been affected by this fire. Mark Reichel, thank you so much.
Thank you for having me.